Welcome everyone to today's Legal Epi at Lunch session. Today we'll be talking about coding case law. My name is Alex Hess. I'm the Legal Training Manager at the Center for Public Health Law Research. And I am joined today by my colleague, Cydney Murray and Linda Tvrdy, who will also be talking about the projects they are working on related to tracking case law and litigation with regard to policy surveillance and legal epi. I'm going to give us just another moment or two as folks are still joining the session, but so happy to have you all participating with us today. If you have questions for either of our speakers, you should be able to use the Q&A or the chat feature. We will have some time for questions at the end for both Cydney and Linda, so please feel free to share comments or questions using Q&A or chat. Also, feel free to introduce yourself in the chat as folks hop on. And again, thank you so much for joining. I'll give it another minute or two and then we can get started. Okay, I think we can go ahead and get started. Again, welcome to today's session on coding case law. I think we'll hear some really great insights for both of our speakers today on how to incorporate and navigate case law and its relevance in policy surveillance. I think that if you have worked on a policy surveillance or legal epi project yourself, you may know that the laws on the books don't necessarily tell the full story. So I think thinking about case law can really help us contextualize the role of law and policy in health outcomes. And both Cydney and Linda today will talk about their experiences doing that and also talk about some of the challenges that they faced along the way. So I think it'll be a really helpful and insightful discussion. I will introduce both of our speakers in the order they'll be talking with you all today. First off, Cydney Murray, pronouns she, ea, is a law and policy analyst at the Center for Public Health Law Research at Temple University's Beasley School of Law. Her research focuses on abortion law, racial health equity, and reproductive justice, and she was awarded a Society of Family Planning Changemakers Award in September 2023. Cydney received her JD from Temple University Beasley School of Law in May 2022 and was admitted to the Bar of New Jersey in October 2022. Before starting law school, she earned a Bachelor of Science in Public Health with highest honors from Rutgers University in May 2017. And Linda Tvrdy is a legal and academic professional dedicated to promoting justice and social innovation through interdisciplinary collaboration. Linda received her PhD in U.S. history from Columbia University, where she specialized in the legal and intellectual history of Reconstruction. A former civil litigation attorney, she received her law degree from George Washington University Law School. So without further ado, I will be turning it over to you, Cydney. As a reminder, I'll be advancing the slides today.
Excellent. Hi, everyone, and thank you so much, Alex, for the introduction and for moderating this webinar. As Alex mentioned, my name is Cydney Murray, and I'm a law and policy analyst at the Center for Public Health Law Research. During my time at the center, I've had the opportunity to work on several abortion law data sets, a few of which I'll be highlighting later on in my presentation. Coding case law can present unique challenges in a data set, so I'm really happy to share a few different approaches that the abortion law team at CPHLR have taken. Next slide, please. Thank you. So while capturing case law may be appropriate and necessary in data sets on a variety of public health law topics, doing so is particularly important in abortion law data sets because abortion-related case law often impacts the enforceability of coded statutes and regulations, such as by limiting the applicability of a codified law. For example, a statute as written may restrict all healthcare practitioners from providing abortion care, but a court ruling may limit the applicability of said statute, such that it is impermissible to apply it to physicians. In effect, the case law would permit physicians to provide abortion care despite the statute's blanket restriction. Case law may also limit the extent to which codified law may be enforced. For example, a statute may create a total ban on abortion without exception, but a court ruling may find it unlawful for such a ban to apply to pre-viability abortions or in cases of medical emergency. Despite the statute's total ban in that case, the case law would in effect permit lawful abortions in instances of pre-viability or medical emergency. And lastly, case law may enjoin certain statutes and regulations entirely, so that they are entirely unenforceable as long as the ruling stands. Also, case law provides helpful and sometimes essential context for understanding our data, such as by indicating when litigation around a certain law is ongoing. After the Dobbs decision, this indicator was especially important as courts were and continue to be inundated with legal challenges to abortion-related laws. While an abortion ban may have been blocked on the day that we coded it, it was entirely possible that a court ruling the next day could put that law into effect. And finally, coders may choose to include a brief explanation of the grounds upon which a law was either upheld, limited, or enjoined. Depending on the intended use of a data set, this information can be useful for evaluators or other end users. Next slide, please. Now that I've hopefully convinced you all of the usefulness of incorporating case law in your coding scheme, please allow me to add a few caution notes. So capturing case law in abortion law data sets can be particularly tricky. One, because the abortion legal landscape is ever-changing and it changes rapidly. As I previously mentioned, an abortion ban could be blocked by court order on the day of coding, just for that ruling to be reversed the following day. In this respect, surveilling case law can be tricky due to how quickly the abortion legal landscape shifts. Finding applicable case law can be challenging as well. For sentinel surveillance projects, for example, which are projects that are conducted in nearly real time, applicable federal case law may not have been officially published in a federal supplement at the time of research or collecting the law. Another example are restraining orders issued by lower courts that may not be as easily accessible or apparent depending on the timing of their issuance and your research. Additionally, the holdings of identified case law can be complicated. While some orders clearly and completely enjoin entire statutes and regulations, other rulings may only partially limit the law's effect, which can be difficult to cleanly capture in coding. For the three challenges highlighted above, trusted secondary sources can be extraordinarily helpful. Other researchers organizations, and projects may be tracking the case law that you're seeking. So cross-checking your research against theirs can provide reassurance that nothing substantive has been overlooked. Lastly, the best way to capture abortion case law varies by dataset. Aside from scoping differences across projects, whether or how to capture case law depends on the intended purpose of the dataset. Before making a coding decision on case law, it's important to consider what the data will be used for. If you're collaborating with researchers on a project, it's helpful and important to know how they intend to use the data exactly. For example, are they only planning to track and measure the impact of enforceable laws? Or perhaps they are interested in evaluating the impact of laws that exist on the books, even if some of those laws have been limited or enjoined by case law. And some researchers are interested in both. Having this conversation with your partners will oftentimes best inform your approach to coding case law. Next slide, please. I'd now like to present 3 examples of how the abortion law team at CPHLR has approached coding case law. As you'll see, each featured dataset incorporated slightly different coding schemes when it came to case law, which was in large part due to differences in the intended use of each dataset. While some researchers were only interested in knowing the existence of applicable court rulings, other researchers requested that the effect of court rulings be explicitly reflected in coding. Again, understanding the purpose of your data will often guide you to the best approach to coding case law. So first up is the abortion bans dataset within the Abortion Law Project database. On the left side of the screen, you can see that our case law questions asked, has the law been limited in whole or in part? And has the law been limited by a court decision? In collaboration with our research partners, our team decided to code both questions yes, where there was a relevant court opinion affecting the enforceability of one or more of the variables coded elsewhere in the dataset. A brief summary of the opinion's ruling, including which provisions exactly were affected by the ruling, were captured in a caution note attached to question 2.1. We added an additional caution note to affected questions with the following uniform language. One or more of these provisions may be limited in whole or in part. Please see question 2.1 for more information regarding its enforceability. If you look to the top right of the screen, you'll see that this uniform caution note was added to question 1 in one of Louisiana's records, because Louisiana's prohibition on the performance of certain abortions was affected by a court ruling. Below Louisiana's box, you'll see an example of the caution notes we attached to question 2.1, summarizing applicable case law. In that caution note, we made sure to list the exact statutes affected, regulations or provisions, and the citation of the limiting case law. You may also note that we flagged the potential impact of the Dobbs decision on the cited case law, given the timing of this dataset's publication on November 1st, 2022. Next slide, please. So next we have the post-op state abortion restrictions and protections dataset. You may notice that one of our questions remained the same. Has the law been limited in whole or in part? But our second case law question in this dataset was, which law has been limited? Unlike in the Abortion Law Project, we explicitly captured the impact of case law in our coding scheme through the addition of this question. If any of the listed variables were enjoined or limited by court order, that variable was selected in question 10.1. As before, a brief summary of the opinion's ruling, including which provisions were affected by the ruling, were captured in a caution note attached to question 10.1. You can see an example of this on the far left of the slide in one of Arkansas's records. Please note that the post-Dobbs dataset was a sentinel surveillance project and was therefore conducted in nearly real time. As such, at the time of coding, Several of our coded laws were subject to ongoing litigation, and several noted cases were still winding their way through the court system. To uniformly address this situation, we instituted the following coding methods. 1, if the law was enjoined or was held unconstitutional, we included the following caution note. X law is not currently in effect. Please see Y case for more information. If that limiting court ruling was based on Roe v. Wade and its progeny, and there was no official update on the court's ruling status after Roe was overturned, the following additional note was included. However, this ruling may be affected by the decision in Dobbs v. Jackson Women's Health Organization. Our second coding method was to include a caution note if the law was subject to pending litigation, but not enjoined. In that case, the following caution note was included. X law is currently in effect, but is the subject of pending litigation, and the status may change. Please see Y case for more information. Finally, if the law was subject to pending litigation and currently enjoined, the following caution note was included. X law is not in effect, but is the subject of pending litigation, and the status may change. Please see Y case for more information. So if you look to Utah on the slide, you'll see an example of this coding convention. We noted that while one of Utah's abortion bans was not in effect at the time of coding, it was still subject to pending litigation and its status was subject to change. Next slide, please. Finally, the Legal Epidemiology of Abortion Policy Status Set, or the LEAP study, is an ongoing project in which we are building select data sets from the Abortion Law Project back to 2005. On the screen are a few snapshots from the abortion ban data set within the LEAP database. As you may notice, this data set is structured similarly to the prior data sets. Here we ask, has a law been limited in whole or in part? Has a law been limited by a court decision? And which law is not in effect? In this case, our partners at Answer are primarily interested in the impact of enforceable laws. So we developed question 2.3 to clearly capture which laws were not in effect in a certain jurisdiction on a given date. As before, we added a caution note to affected questions with the following uniform language. One or more of these provisions may be limited in whole or in part. Please see question 2 for more information regarding their enforceability. Unlike the prior two data sets, however, we are not capturing the summary of court rulings and caution notes, but are instead providing a brief summary in a source box, as you can see on the bottom of this slide. We're then citing to that source and summary in our coding of questions 2, question 2.1, and question 2.3. This coding scheme provides our partners with the information they need while also freeing up the data set from quite so many caution notes. Next slide, please. And that's the end of my brief overview of how we've addressing the case law and abortion law data sets. But happy to talk about this further in Q&A. And beyond that, please do stay in touch. Thank you for your time.
Thank you so much, Cydney. That was an excellent presentation, and I think really helpful to see sort of the different ways you can capture case law, and really note that there's not one single way to approach this, so I think that's really valuable too. So we'll go ahead and save any questions for Cydney for the end, but feel free to post them in the Q&A. The chat wasn't working, but it should be now if anybody would like to use that. And we also had a question about the recording. So this should be available after the session. You should get an email with a link to the recording so that you can view it later on. All right, well, thank you so much, Cydney. And now I'll go ahead and turn it over to Linda.
Thanks, everybody. My camera's not working, but that's probably for the best. Thank you all for joining us. As Alex introduced me, I'm Linda Tvrdy, and I'm the Senior Legal Program Manager for Public Health Law Watch. Public Health Law Watch is, it began as an initiative by a group of public health law academics called the George Consortium. Public Health Law Watch operates within the Center for Health Law and Policy at Northeastern University School of Law. We are one of the partners in the Act for Public Health, and our responsibility with the Act for Public Health is to track litigation that impacts public health authority in U.S. courts and to use legal epidemiological methods to better understand what's actually going on in the courts. We created a data set that included 1,200 court decisions that were issued between March 2020 through December 2022. And just for the record, when I say we, I mean the team at Public Health Law Watch. I started working with Public Health Law Watch in November of 2023, so I get no credit for any of this work, but our team created this database. And we used legal epidemiological methods to code these judicial decisions that affected public health authority in state and federal courts. Some of the data points that we collected were included where the public health measure, the measure that was being challenged, was enacted. That is, whether it was a state, local, or federal measure. We also coded for the topic or measure being challenged, like was it a business closure, a mask mandate? We coded for the legal issues that were raised by the challengers, and we coded for the outcome in terms of whether it was in favor of the challenger or in favor of the official exercising public health authority. Oh, I'm sorry. Could you... Sorry, Alex, I'm actually on slide 3. Yes, sorry about that. So, no, I'm sorry, slide 2, I guess, one back. Thank you. So anyone who has ever spent a lot of time reading legal cases knows that it can be difficult to categorize any judicial opinion into the binary categories of a win or loss. One thing we learned in this process is that we probably need to have some way of weighing outcome data. I'll give you 2 examples of just 2 examples, but there are, I could give you 100. I've seen courts deny a motion to dismiss, but warn the so-called winner in that case that they just barely escaped dismissal and that they'd better be prepared to come back with better statement of their case. That's a win, but it is also very much, it's not clear. The court, I've also seen courts grant the motions to dismiss, but with leave for the so-called loser to fix their defects and come back and refile their complaint. Again, a win, but not or a loss, but not a clear loss because they get a do-over essentially. So it will be useful for future coding judicial decisions, I think, to figure out a way to weight them, or just maybe a way of coding that captures that kind of nuance. So that's for the future. For our database, we were able to determine within our database, we were able to measure some important things. One of them was that during our time frame, the vast majority of challenges to public health authority were fought back. So the public health authority, the public health officials exercising authority won in about 79% of the cases. That said, many of the challenges to the public health authority during this period, many of those challengers asserted novel legal grounds that ran counter to longstanding precedent. And during this time, courts showed a new willingness to entertain these challenges. So in times of settled legal doctrine, novel legal grounds tend to get very little attention and very little consideration by courts, but we were seeing courts that were entertaining these in ways that were somewhat unexpected. And even courts that decisively rejected these novel challenges felt compelled to write. I say felt compelled. I don't know whether they were compelled, but they certainly did write lengthy opinions explaining their reasoning. And that seemed to indicate that we all should be taking these a little bit more seriously, these challenges a little bit more seriously. One challenge that I saw a few times was based on the idea that the supremacy clause has a private right of action in it somewhere, meaning that where the issue of whether a state versus whether a state law is preempted by a federal law is something that a private individual can go into court to argue without any other kind of underlying harm to them. So you can just say, this public health measure at my state is unconstitutional because of the supremacy clause. I mean, I was gobsmacked to see that, but I was even more surprised to see the court engage in a lengthy explanation as to why that private right of action didn't exist. I considered this kind of a signal, this type of thing where courts are considering doctrine that they would have dismissed out of hand in earlier times to be kind of a signal that there is something going on that we need to pay attention to. We were able to do that because in addition to analyzing the structured data that we were creating from these decisions, we also analyzed these cases the old-fashioned way by reading them and writing them up and sharing out what we learned. We did this through, goodness, I'm not paying attention to the slides. So if you could go one more, please. Thank you. And actually, you can go to the next slide as well. We shared a weekly recap of the cases that were coming out with a short analysis. Our faculty director, Wendy Parmet, published deeper analyses as we were going through, as we were collecting the cases and analyzing them, trying to understand what was going on in real time. So we sort of were trying to offer a kind of early warning system. And as time went on, Wendy and the team identified a couple of areas, identified one thing that was happening right away, which was that the amount of deference that the courts had shown to public health authorities in the past, to the expertise, to the knowledge of what to do in an emergency, courts had previously deferred to the scientific and public health expertise of public health officials. That deference was on the decline. In some cases, courts were making decisions without considering the science at all. The other thing is there were two general areas where we saw public health had become vulnerable. Those were claims alleging impingement on First Amendment religious freedom or religious discrimination, and claims that government officials had exceeded their legal authority to act. So those are two big areas. If you could go to the next slide. Yes. I'm so sorry. Yes. So this combination of structured data with real-time analysis turned out to be an effective early warning system that pointed to some really important doctrinal shifts. Next slide, please. A recent study conducted by Professor Michelle Mello at Stanford and her team there that used legal epidemiological methods to examine a subset of the cases that challenged public health authority during this general time frame. That subset included the challenges that were successful. And the findings in this study, which are discussed in this article that you see by Professor Mello, her colleague David Jiang, and Wendy Parmet, were very much in line with the kind of interim assessments we were able to do as we were tracking the litigation in real time. So what this consistency between our interim findings and Professor Mello's later study pointed to the very real possibility of using legal epidemiological methods as a tool for monitoring rapidly evolving doctrinal changes for public health authority, or really for any area in which the law has become unsettled and is in the process of becoming resettled on different terms. Next slide, please. What I'm envisioning here is a sort of early warning system that can detect the rumblings of a doctrinal shift early enough to understand the ramifications of that shift, and then to advocate for a resettlement of the law that promotes rather than hurts public health authority. The data's out there, but there are challenges in gathering it and challenges in coding for some of the complexity involved in litigation. This slide sort of is intended to sort of touch on some of the complexity. I mean, the hierarchy of the courts is one, right? So you start out at the trial level, you move up through the appellate levels, and as the appellate courts are making decisions, their decisions can affect the law back downstream. So you've got this upstream, downstream process that is that has to be captured. And then right now, we also have federal courts really deciding the Constitution. Well, first of all, doing nationwide injunctions. The federal district courts imposing nationwide injunctions is a relatively new thing that is being used a lot, and it affects everybody across. So even if the issue is a state court issue, if it's decided on constitutional grounds at a trial court and in the federal court system, that federal court can impose a nationwide injunction that will stop the enforcement of laws in every state, as well as within the federal system. So that is really sort of tough to capture. Federal courts also, as I mentioned, decide the constitutionality of state laws. So you have to include both the effect of federal courts interpreting state laws. And then the complication of the Supreme Court's shadow docket, which grants preliminary relief on the basis of theoretical facts, as opposed to facts that have been established at a full hearing of the issue. How does that work? And how do we incorporate that into what we understand as both precedent and signaling a doctrinal shift? The next slide, please. So despite the complexity, I mean, I think the complexity is something that just needs to be, we need to think about it and work on it. I think it's a challenge that is doable, even if it may be difficult and complex. And it's really important, I think, because we are in the midst of some pretty seismic doctrinal shifts. This is a super oversimplified version of the kind of thing that I have in mind and that I hope that we can one day build. And it starts with the tracking and coding of cases, and it looks for the outcomes and the reasoning, and we can code in a nuanced and sophisticated way. But then we apply the human in the loop by having experts analyze and separate signal from noise and detect some rumblings or shifts or something afoot in the legal doctrine. Then we refine the coding protocol to capture those rumblings and monitor those rumblings of the potential changes in legal doctrine. And it's sort of a surveillance feedback loop that I've got in mind. And I think that there is real promise here. I hope there is. Next slide, please. There's another challenge in this, but I kind of think of it as an opportunity, and that is, how do we capture case data at the earliest possible stages, or case data that never gets published? A case dismissing a novel legal claim out of hand might not make it to a published decision. That's important because it suggests that it suggests the continued validity and viability of settled doctrine. This information lives in docketing systems and electronic case filing systems, but how do we get it out? How do we find the relevant cases? One thing that we're doing right now, which is very, handcrafted, is to find organizations like these three that you see on your screen that are engaging quite openly in movement litigation to undermine aspects of public health that we want to protect. So we just do a search in like, for example, Bloomberg's docketing system for the names of these organizations to find the cases that they've filed. And that's kind of like breadcrumbs to look for other cases. Another method that we haven't tried yet, but is worth exploring, is just these organizations, we kind of can assume that they're using brief banks and using, guidelines. I know for sure that Children's Health Defense has brief banks and even form letters to send to your legislators to demand things around vaccines and against vaccine mandates. So there is standard language that we could search for. Anyway, I'm sort of getting out over my skis a little bit about the possibilities. But I will say that this kind of a surveillance system is necessary because of the doctrinal shifts that we're experiencing right now, and because of these organizations that are poised to step in to the chaos, if you will, and see that the law is resettled in a way that harms public health and we need to be able to step in and counter those arguments. And being forewarned is being forearmed. So if we can detect this activity, and we can detect the doctrinal shifts at the earliest possible stages, we can be really effective in protecting public health and public health authority in the law. Thank you.
Thank you so much, Linda. And thank you both again for those wonderful presentations. And I think it was so interesting seeing how different and similar all of those projects are. I think that it's really helpful to get an understanding of the role case law and litigation really have in thinking about policy surveillance, legal epi. It provides so much more context than just tracking the laws on the books, as you both know so well. And I think you both have had really different approaches to how you've done that in each of these projects. And I think that really speaks to the way these methods can really be flexible to apply that analysis, and also to really emphasize the importance of case law. I've even worked on some projects myself at the center. I'm thinking of our preemption project, which I think really correlates to both of your projects, really, and thinking about the way states preempt local governments, but how there's, I think, a big movement, or at least the thoughts are being brought up in spaces where folks are talking about preemption and how it can really stifle public health, thinking about these legal challenges to those laws and how those strategies and doctrines can be applied across jurisdictions. I think we're seeing a lot of the same things we see with just policy itself, how, for example, model legislation can kind of take off in a lot of jurisdictions, or we'll see a lot of the same language. I think we can apply that with legal doctrine and how that can really percolate in several jurisdictions, and that can support thinking about these legal strategies to challenging laws that really stifle public health. Does anybody from the audience have questions for either of our speakers? And again, you can use the Q&A. The chat function should also be available to you now. I'm not seeing anything at the moment. I guess the question I had for both of you was really, what was the biggest challenge in undertaking each of these projects? I think there's a lot of challenges when approaching this, especially when you're just thinking about time and resources and how long it can take to really sift through all this case law and analyze it. I think it works a little bit differently than when we're working with policy specifically. So I'm curious to know if either of you had any major takeaways. I think you both kind of spoke to this, but just to sort of summarize your findings or what you see moving forward as you plan to keep on tracking case law litigation as you go forward with these projects. If there's anything you would do differently or anything you've viewed as the most challenging piece of all of this.
I can name one sort of big challenge, and it has to do with, for example, it has to do with this doctrinal shift that I was talking about. So we coded for different legal challenges, and one of our the coding. So like one of the categories for legal grounds was to challenge the scope of authority, meaning that just simply that the statute that gave the public official the authority to act did not give them the authority that they took, the full authority. So that was one, but then in the middle of all of this, the major questions doctrine, Neil Gorsuch described it in a dissent, actually. And so all of a sudden that is relevant to cases. And so like, how do you, when you've sort of, how do you code for that? Is the major questions doctrine just another flavor of scope of authority, or is it something new? And how do you in real time, as you're collecting cases that are coming down in real time, how do you update the coding? So like if I were, and sorry, I'm taking too long to answer this, but if I were to go back and collect all of the cases, all of the cases from a period of time in the past, it's sort of static. I mean, it can change because of decisions and overturned cases, but the doctrine that exists in those cases won't change anymore, or like it's just a more static database that you can code reliably. But a database of cases that's sort of happening right now, the cases are still pending, they haven't even had a decision rendered, a whole new ground for deciding that case can emerge, and understanding what to do with that it's both the most important thing in my view to capture and extremely hard to capture.
Sure. Thank you. Anything you'd like to add to that, Cydney?
Yeah, I think like relatedly, and I talked about this in my presentation, it's just everything just moves so quickly. And I think that especially post Dobbs, like case law was always consequential, but I think the impact was just felt so much harder and so much more immediately after Dobbs of just like gestational periods in terms of when you can access that care and like when you couldn't would change like overnight. So I think like that was just really challenging, especially in the post-Dobbs data set of like how do we keep up with this, because it was just so consequential where the stakes felt higher of like missing a restraining order, or something of that nature really did directly impact coding so severely almost. So just really refining our research methodology in terms of like where we were looking for case law, what secondary sources we were checking up against, on top of how are we then going to capture this like in the data set in a way that is makes sense, it's accurate, and it's accessible for our end users and our partners, was just really an interesting experience, definitely challenging, but we figured it out, which was very rewarding, I think.
Yeah. I think this question from Cody Reynolds is maybe getting at what you both have spoken to a bit. How do you disseminate policy surveillance and or legal epi results to the public or providers? For example, informing providers of updated abortion laws, etc. So I think that really is getting at the way this is such a rapidly moving landscape. And if either of you would like to answer, feel free.
I can take like a first stab at this. I think that one way is just that through our collaborators. So for like the abortion law project, like we were working with the regulatory assistance for abortion providers, which was like a project of RAD. So there was kind of like that direct line of like our information getting to the hands of providers. And then beyond that, like we're working now with like Answer, and I think that we are kind of plugged into a lot of organizations that kind of provide this direct through line between our data and ensuring that it's like disseminated to people that are directly impacted in terms of like knowing what the law is in terms of their practice.
Yeah.
So I mentioned it in the presentation too, is that we have this weekly newsletter that provides, you know, updates and recaps, and then the analysis that Wendy Parmet published in different outlets, and also, you know, just the media. We have partners, and we try to disseminate this information through partners in the public health law space, but I think it would, I'm open to ideas. We talk about this all the time among the partners, is how do we get this information into hands that can use it? And I think we're in the middle of thinking about what the infrastructure looks like that would make that efficient and possible in a way that it isn't right now.
Thank you. Thank you both for the answers to that question. Any other questions for our speakers today? All right. Well, I will give you all a few minutes back in your day. But again, a huge thank you to Cydney and Linda for those presentations on capturing case law and litigation in policy surveillance and legal epi. I think those are some really great insights. And I think you spoke really well to those challenges that you faced along the way. But I think these capturing case law in this way, I think makes the data set so much more valuable and provides so much more information. And I think it also makes it more valuable to folks who may not otherwise, be interested in a data set that's just looking at, statutes and regulations, for example. I think it makes it a more dynamic data set that has a lot of value. And so I encourage you all, as you work on your own projects, for those participating with us today, that you also think about the role of case law. And we'd also be happy to answer any questions you might have. I know Cydney's contact information was in the slides, but if you'd like to reach out to Linda, feel free to contact us. And so we'll put you in touch. But I think you can find Linda pretty easily on Northeastern's website. So without further ado, thank you so much. Have a good rest of your day, everyone. Bye-bye.